Hi, my name is Andy Friedman. I'm a partner in the law firm Friedman, Rosenwasser & Goldbaum. Today I'm going to talk about reviewing and understanding the franchise disclosure document. The franchise disclosure document contains 23 items of information about the franchisor, about the relationship between the franchisor and the franchisee, and provides you with information to help you conduct your due diligence in buying a franchise. What I'd like to do today is go through each item of the franchise disclosure document and explain to you what I think is important and what you can get out of the franchise disclosure document in conducting your due diligence. To start with, the franchise disclosure document has a cover page that has some required information the franchisor is required to provide you with. For example, the cover sheet requires the franchisor to disclose the initial investment that the franchisee will be required to spend in order to start the franchise and operate it for at least 3 months. So right from the cover sheet, you can determine whether or not you have the financial ability to buy that particular franchise. Item 1 of the franchise disclosure document gives general information about the franchisor, their history, something about their affiliates, any predecessors, and gives a general description of the franchise that's being offered and any regulations specific to that particular franchise system that you should be aware of. So this is just general information. Item 2 of the franchise disclosure document describes the 5-year employment history of the franchisor's officers, directors, and those people with management responsibility over the franchise. Item 3 of the franchise disclosure document discloses any litigation that the franchisor has had with its franchisees or any material litigation. Now, when I look at a franchise disclosure document and see that a franchisor has been involved in some litigation, that does not concern me. However, if I see a pattern of franchisee lawsuits against the franchisor for things like fraud or violation of the franchise disclosure laws, that will raise my antenna and wonder whether or not this is a good franchise for my client. Item 4 of the franchise disclosure document describes whether or not the franchisor, its predecessors, or its officers or directors have filed bankruptcy in the last 10 years. To me, this is not significant. Item 5 of the disclosure document describes the initial fees that the franchisee must pay the franchisor. So this will include the initial franchise fee, which can range anywhere from $5,000 to $50,000 or more. And it will also describe any other payments that the franchisee is going to pay to the franchisor before the franchisee opens for business. So that might include product purchases, inventory, equipment, and things like that. So this is helpful to get an idea of how much you're going to pay the franchisor initially. Item 6 of the franchise disclosure document describes in a table format all of the fees that the franchisor will or may charge the franchisee during the term of the franchise agreement. These fees will include the initial franchise fee, the royalty fee that the franchisee will pay to the franchisor, which is often a percentage of gross sales, but it also might be a flat amount. It will describe marketing fees. Many franchisors have a common marketing fund that they use to generally advertise the franchise or the franchise services, and the franchisees typically required to spend anywhere from 1 to 3% of their gross revenues to pay to the franchise's marketing fund. And then it'll have a list of all of the other fees that the franchisor may impose. This is helpful, but it does not substitute for reviewing the franchise agreement in its entirety. Item 7 of the franchise disclosure document is one of the most important items for you to review. This is also in a table format and describes all of the expenses that you should be required to pay or may be required to pay in order to start the franchise and operate it for at least 3 months. So some of the items in item 7 that will be disclosed are the initial franchise fee, any real estate acquisition costs, equipment purchases, build out of a facility. It will include permits and licenses, professional fees, inventory, grand opening expenses, other advertising expenses, and something called additional funds. And the additional funds is usually the last item in item 7 that describes the other expenses that you may incur in the initial operation of your franchise business. So at the end of item 7, there will be a total estimated initial investment requirement, which will be in a range of fees. So it may be $100,000 to $150,000, for example. And the range of fees will vary because each franchise is different because of different geographic areas, different expenses, different experiences. Each franchisee will have a little bit different budget to start their franchise. So again, like on the first page, or the cover page of the disclosure document, you'll be able to glance at item 7 and determine your initial capital requirements, and you will know whether or not this franchise is within your budget or not. Item 8 of the franchise disclosure document describes the products and services that you're going to have to purchase from the franchisor or from sources designated by the franchisor. And this is really important because some franchisors have been accused of abusing this system or process of requiring franchisees to buy product or services from designated suppliers or from the franchisor itself. And when these fees or expenses are in excess of fair market value, then the franchisee is being punished for being within a franchise system. This obviously does not make sense. The franchisor should help the franchisee to achieve the lowest prices possible on their products and other ongoing services that they may be required to purchase. So it's very important to review item 8 to determine how the franchisor imposes these requirements to purchase products from the franchisor or from sources designated by the franchisor. And also item 8 will disclose if the franchisor receives any rebates or kickbacks or other compensation from the suppliers based upon purchases by franchisees in the system. Now, it is my opinion that the franchisees should benefit from any bulk purchasing that the franchisor and its other franchisees can obtain from suppliers, where a franchisor takes those rebates or kickbacks and puts it in its own pocket. I find that offensive. There are other ways the franchisor can make money, and the franchisor should be making its money on the royalty fees that it charges you, not on product purchases. Item 9 of the franchise disclosure document is just a chart that cross-references certain subject matters and where it's found in the franchise disclosure document or in the franchise agreement. This is not really helpful to me. Item 10 of the franchise disclosure document describes whether or not the franchisor offers any financing and the terms and conditions under which they might offer financing. However, most franchisors do not provide financing, and a franchisee is either going to have its own money available or go to a bank or other third party for financing. Item 11 of the franchise disclosure document covers several different subject matters, including advertising requirements, computer requirements, and training requirements. So, for example, the franchisor will describe what it will do for the franchisee before the franchisee opens for business, and then separately what services the franchisor will provide the franchisee during the operation of the franchise business. For the training program, the franchisor will be required to provide a chart describing how many hours of training the franchisee must attend, including a breakdown of on-the-job training and classroom training, as well as the location of where the training takes place. Now, most of the time, the franchise training takes place at the franchisor's headquarters or at the franchisor's corporate store. Another thing you will want to look at in item 11 are the computer requirements. So the franchisor has to disclose to you what types of computer equipment, hardware you're going to be required to purchase, as well as software that you might be required to purchase or license, whether it's from the franchisor or from a third party. The franchisor will also have to disclose the range of fees that you might incur in acquiring the computer hardware and software. Keep in mind that most franchise systems have a provision both in their disclosure document and in their franchise agreement that permit the franchisor to impose new and additional computer hardware and software requirements at any time during the course or the term of the franchise agreement. So one thing you want to keep in mind is as technology advances, you may be required to buy new computers and new software, and you need to keep that in mind in budgeting your cash flows. Item 11 also requires the franchisor to describe to the franchisee the advertising requirements. Now there's probably three parts to the advertising requirements. One, the franchisor may require you to spend a certain amount of money, $5,000 or $10,000 for example, on a grand opening advertising program. Secondly, the franchisor will probably require you to spend a certain amount of money or a certain percentage of gross sales on local advertising, on advertising your product or services in your geographic territory. And finally, the franchisor will probably have some sort of marketing fund that they will collect a percentage of your gross revenues, usually 1, 2, or 3%, and you're required to pay that to the franchisor. The franchisor uses that money to generally advertise franchises or to generally advertise the franchise system in any way it deems advisable. Keep in mind that you will not necessarily get the benefit of the advertising dollars that you pay into the marketing fund because the money may be spent in other geographic areas or on administrative expenses or other expenses that don't directly benefit you. In item 12 of the franchise disclosure document, the franchisor has to describe the territory in which you are granted the right to operate the business and whether or not you are granted an exclusive territory. Now, exclusive territories are a little misleading, and the state regulators have now changed the language in item 12 so that if the franchisor does not provide an exclusive territory, the franchisor has to disclose that fact by stating, "We do not provide exclusive territories." What you need to be aware of when a franchisor says to you, okay, we're going to give you the right to operate a business, whether it's a service business or a product business in a certain geographic area, the franchisor in many cases reserves the right to sell competing products through different channels of distribution. For example, the franchisor may sell competing products or services via the internet, via catalog, or by other means. In item 13 of the franchise disclosure document, the franchisor has to describe the trademark rights it has in its name, and it will typically show in a chart the trademarks that it owns and the filing date or issuance date of their franchise registrations. If the franchisor does not have a registered trademark with the U.S. Patent and Trademark Office, it has to advise you of that fact in bold language so that you are aware the franchisor does not have certain rights that one gets when they have a registered trademark with the U.S. Patent and Trademark Office. In item 14 of the franchise disclosure document, the franchisor has to describe whether or not they have any patents or trademarks or copyrights that are material to the franchise. Most franchise systems do not have any patents or copyrights, but most franchisors will claim copyright ownership in their operations manuals and other confidential information. In item 15, the franchisor has to describe whether or not the franchisee must actually participate in the management and operation of the franchise system. In some franchise systems, the franchisor requires the owner of the franchisee to be actively involved in the business. Other franchise systems allow so-called absentee owners. Item 16 discloses the restrictions on what the franchisee may offer or sell. So, in almost every franchise system, you will be required to offer and sell all products and services that the franchisor designates, and you'll be prohibited from offering any services or products that the franchisor does not approve. In item 18, the franchisor has to disclose whether or not they use any public figures to help sell their franchises. Item 19 of the FDD is one of the most interesting and controversial items in the franchise disclosure document, and it has to do with financial performance representations. Let me first give you a little bit background. The previous rules on franchising referred to these financial performance representations as earnings claims. So a lot of times we still use the phrase earnings claims. And historically, most franchisors did not provide any financial information to the franchise prospect other than the expense information that's disclosed in item 7. So franchisors did not, for a number of reasons, disclose to a franchisee how much the franchisee might make. Now, when you go out to buy a franchise, one of the first questions you're going to want to know is, how much money can I make, or what is my return on investment? And historically, most franchisors would say, well, I'm not allowed to tell you. Now, that was not exactly accurate to say that they were not allowed to tell you, but it was either too cumbersome to tell you the financial information, or there was a risk. Franchisors felt there was a risk that if they provided you with financial information or pro formas or actual revenue figures from other franchisees, and if you don't achieve that level of sales, then you might sue the franchisor and say, hey, you said I was going to be able to make $1 million and I didn't. However, about 6 years ago, the law changed and it became easier to make these financial performance representations. So today, I don't know if it's 50%, but maybe close to 50% of franchisors do provide some financial performance representations. However, I would caution you, because most franchisors will give you the average unit sales. Well, you're not going to be buying the average unit. You're going to be buying one unit. So I would take these financial performance representations with a grain of salt and rely more heavily on information that you can get from existing franchisees as to what their sales and revenue figures are. Item 20 contains 5 different charts that are very helpful to determine the direction that the franchisor is taking. So for example, it will disclose over the last 3 years how many franchises the franchisor has sold and how many have been terminated or no longer in the system. So I think it's important to know if a franchisor is growing, they've added new franchises over the last 3 years, or if they're going the other direction and losing franchisees. Obviously, you want to look for a franchise system that is growing and vibrant and robust. In item 21 of the franchise disclosure document, the franchisor has to provide you with audited financial statements for the last 3 years of operations. Now, you may want to have your accountant review these financial statements, but what I do is I want to look at the financial strength of the franchisor. So if I see the franchisor has, for example, a negative net worth, or their cash flows show that they will not have any money by the end of the year, I would be very lenient to buy a franchise in that system. Item 22 of the FDD describes or just lists the contracts that you may be required to sign when buying the franchise. Obviously, that will include the franchise agreement, but you may also be required to sign other ancillary agreements such as a personal guarantee, a confidentiality agreement, a non-competition agreement, and things of that nature. Finally, item 23 of the disclosure document is a receipt. So the franchisor will require you to sign a receipt for the franchise disclosure document because they are not allowed to sell you a franchise, have you sign a franchise agreement, or pay any money to the franchisor until the expiration of 14 calendar days from the date you sign that receipt page. This concludes this session on reviewing and understanding the franchise disclosure document. I hope you found it helpful. If you have any questions, feel free to email me or visit our website, franchiselaw.com.